No. मेरी मेंटली काफी सारे 948 or 2020. The opposite button, that is not. So given 2 weeks time to file the bill. But 2 weeks are over, they have not filed the bill, it will be listed on Monday. Then you have to be.
Are you mentioning upon notice? No. Are you mentioning upon notice to the opposite party?
Oh, no. I just spoke to the other side.
Have you informed
Yes, I have.
that you would be mention it today? So where is the opposite party?
So Arun Chandra Kumar is there. I'll send the official communication also. Let me this on Monday.
Okay, let it appear on Monday.
This matter. Item number 18. Discharge order was challenged by the CBI, and the discharge order was passed by your lordship while functioning as session judge.
Item number?
It should go
Where?
18 to 21.
All the matters.
Yes. Even if it is there, we will
Okay.
74 and 75 in the list.
Let him pass the order. Please take down. Item number 18 to 21 are the connected matters.
Arising out of same order.
Okay. Item number 18 to 21. The matter cannot be taken up by this court on personal grounds. Accordingly, the matter be go out of the list and list those matters in the next available circuit. Yes.
Lord, our presence in this matter will be recorded, the one which is taken up in the next circuit, and therefore I can tell you. Thomas allegation. My preference, except for all parties.
Parties are present. Learned advocates are represented.
74 and 75.
Yes.
Why I insist for upgradation of these matters is for a solitary reason. The reason is these two petitioners are lawyer practicing in this island. They had some grievance with regard to the helicopter tickets. And since Malad is equipped with all these schemes which is prevailing in this island, if these two matters are upgraded, this is for the second time I'm coming. First time, second orders were passed by this court that has not been adhered to. These 74 and 75, it's very issue is very short and very limited. That's the point. We have a courts in different part of the islands. We have not been given a heli ticket during those periods. First week of every month except May. This is the issue. Already this court, the quantity bench have decided this issue, but the orders were passed in derogating to those directions. I've challenged that one. Monday. Or if not time permits, I can. This one urgency has taken wait for Monday also. I've waited for these many months. On Monday, some updation.
Who is appearing for the administration?
Mr. Ramandu, I have put in notice. I have already said told them.
Okay. Please take down. Item number 74 and 75. Both would be separate order. On mentioning, the matter be upgraded. Let the matter appear within the first 5 matters on 16. 74 and 75 separate orders.
Your Lordship, I want to mention item number 99, Your Lordship. There is urgency because the authorities are trying to give promotion to the private respondent, ignoring the office memorandum issued by the Government of India. Now they're in the process. If this matter goes to the next circuit, in the meantime, they'll give promotion and third party interest will be created. I have to implead him as a party and all those things. So item number 99 may be given some preference, Your Lordship. It may be upgraded so that this matter can be disposed of. Everything is completed. I'll give advance copy of the reply also to the other side.
Okay, item number 99. On mentioning this matter, item number 99 be upgraded within first 7 matters
Your Lordship.
on 16th.
Oblige, Your Lordship.
Call the list.
Item number on.
Lord, I am for the
On of content two.
Appellant Miller appearing along with my learned friend Miller. Served
I am for,
paper book for all the parties.
I am for the owner. Hardly.
I'm for the other. I'm for Salman. Huh? Monday it can be, it's a motor accident, train tribunal or lordship, this can be a very short matter.
It's based only on calculation.
Yes, calculation.
Give me what is the calculation? Calculation. Who is for the claimants?
I'm for one of the claimants. That is claimant number 2, Bhakti Tali.
I'm for Salman. There are 2 claims.
Both are brothers and sisters.
Some strain relationship development, so 2 lovers have been naked.
For the benefit of the land.
Brothers and sisters, some relationship has gone wrong, both have been naked.
Let it maintain before this court. Okay. What is the income?
Melody, he was a bachelor, Melody, he was auto driver.
Bachelor auto driver. Very
The
well.
notional income has to be taken, accident took place in the year 2010. 3,000 is the amount, notional income. The court granted 6,000.
166.
Yes.
Very well.
And 166, you also know that it is to be proved by adducing evidence. That was not done. Third point is that, Melody, there is no route permit.
There is no route permit.
Route permit.
Very well.
And third point is that is a bachelor and deduction should be 50%.
Yes.
1/3 was,
1/3 was rejected.
these are the 3 points.
So you are accepting 3,000 per month
Yes.
and only 50% deduction is required. And next point is
Route permit is not there.
route permit is not
And
there.
fourth point is that multiplier 17 is to be applied. The Leonard court will apply 18.
What is the age?
23 years.
23 years.
17.
According to Sarla Verma, it would be
17.
17.
Court granted
Yes,
18.
17. Within 21 to 25, 17.
17. Court granted 18.
18.
These are the only 4 points only. Very short matter. They are agreeable. Monday it can be fixed as I.
No, it can be disposed of now.
Yes.
It can be disposed
Only
of.
thing is that, Your Lordship, if he is insisting upon the point of route permit, then I have to argue the matter. Because otherwise there will be difficulty.
No.
If it is not raised, then, Your Lordship, there is no issue.
It was not raised in the appeal also.
It was raised before the court.
No. Let
Yes,
it be looked
show me
into,
the,
because owner will be
the
responsible then.
impugned judgment. Show me the impugned judgment.
At page,
Whether you have
page 80.
no, whether you have raised this point.
Yes, my lord.
Simply denial is there.
My lord, 86. Please allow me to submit.
Yes, please. Tell me.
86. Last 4 lines. Had no route permit.
Hey,
86, my lord. Bottom 5 lines, last 5 lines. On the place of accident is far from the route permit. Permitted route.
Whether you have adduced any evidence.
Yes.
You have adduced evidence.
DW1.
DW1.
Yes.
Show me DW1.
My lord. 65.
Page 65.
Yes, 65 the operation. Sorry, 62. Deep examination, third paragraph of this is in compliance with the direction of this court. Got it, Mullah?
Yes.
I have brought the certified copy of the route permit of the bus bearing number so and so. The said vehicle was initially registered against the name of R. Umapati. Subsequently, the ownership got changed in the year 2017. And name of MD Inayaraj was registered as owner of the said vehicle in the year 2017. The bus was initially permitted route permit to play route of Aberdeen Bazaar to Kerala Bar. You should kindly take a note. In the year 2008, the permission route permit was granted to play Aberdeen Bazaar to Garacharma PTA College. The accident took place beyond that. This is the certificate copy of the extract of the said route permit in respect of the vehicle bearing number so and so. Exhibit P2 may be seen. Yes, route permit is page 66. Serial number 5 may be seen. Serial number 6, right hand side 5 may be seen. Aberdeen Bazaar to Garacharma PTA College and vice versa.
Yes.
The driver went beyond that route permit.
Where the accident happened?
Yes.
On what basis? There must be some basis.
Yes.
Because claimant said that it's in Garacharma.
Garacharma is a big area.
That's why, but I can fly the vehicle.
You can play the Garacharma permitted. No. Only one permitted area.
And Garacharma is.
Where is the FIR?
23.
Yes.
Place of occurrence near Amberbar, Garacharma.
Garacharma.
Yes,
That's included.
but accident. No. PTA is prior to that.
How he can, how he is establishing all this, not yes and no, but it is to be established. Whether it is beyond Garacharma, before Garacharma or whatever.
Not know that.
It's not about the knowledge of the court. Yes, it has to be established.
And kindly see the income measure, national income. Auto driver, no pay certificate was filed, 6,000 was taken into account. No pay certificate was filed. No income certificate was there. 6,000 was awarded. Actually, 2010, the national income is 3,000 only. Page 88, Mother. Page 88. Page 88, para 2. Second para. As
Yes.
far as income of the disease is concerned, there is no oral or documentary evidence on record. In the claim of inflation, it has been stated that the deceased was a private auto driver and his monthly income was 20,000. It is quite hard to digest the fact that in year 2010, the monthly income of the private auto driver would be around 20,000. That apart, no document in order to prove the income of the deceased has been filed. However, considering the nature of the work, the income of the deceased can be taken rupees 6,000 per month. 3,000 national income in the year 2010. The claimants are certainly entitled for some amount, but not this amount allowed. And regarding 1/3, page 89.
Yes.
Page 89. In view of the fact that at the time of accident, the deceased was unmarried, it would be appropriate to restrict the deduction for the personal expense of the 1/3 of the monthly. It should be 50%. Therefore, 67,200 per annum. As the income of the deceased ought to have been taken into consideration, determination of compensation. Having regard to the age of the deceased, if we multiply 18 would be most reasonable. Age is 23, mother. Multiply 17 will apply. So the judgment is required to be modified.
So what is the final award?
Final award number 12,19,600.
With interest at the rate of 6%.
It is always there.
Now, what are the general damages? Funeral expenses 5,000,
Loss of estate.
loss of estate 5,000. Only 10,000.
Yes.
And actually, the son died, mother filed the claim for the case. During tendency of the motor accident and criminal, mother expired. Legal as well as substantive. They are not depending upon the deceased.
No, when the accident took place.
They are not depending upon the deceased. The dependency also, per head 10,000 was awarded. That is also wrong.
Where per 10,000 awarded? This is the appeal by insurance company? Yes, anything?
That's all. It is there, dependency, page 89. It's mentioned as dependency loss,
Loss of dependency.
amounts to 4,9,600. They are not depending upon the deceased. I can say that the mother is alive, then mother can be a dependent. Not the brothers. They are married, living separately.
By that time, they were
I
minor.
am not yet finished.
They were minor.
You always try to support before we can normalize.
The 3-year COVID period is to be deducted.
Our son has died, not on my brother is on a COVID.
Okay, just wait.
My son has died.
If you are entitled, you get.
So, the constitutional bench decision of pronunciation was also considered.
Yes, yes.
That has to be admitted.
I cannot travel beyond the records.
Yes. Very well.
2010, university is recent. 2010, you have to see.
No. Pronunciation says all pending applications and pending appeals, the ratio has to be followed. This is the judgment of the constitutional bench. So 40% is the future prospects and 70,000 is the general damages. It was not considered. In that case, it would be 30,000, as there is no consortium like that. 40,000 is the consortium, 30,000 is the general damages. And general damages is given only 10,000, I think.
And multiplier also only be deducted.
Yes, multiplier would be
70.
70.
And in personal expenses, 50%. 1/3 was.
That has to. Very well.
That's all.
Yes.
Notional income, we will have to find.
You should let me finish it because my argument is only one line. You see, as per the FIR, it states that an accident occurred near Amber Bar, Garacharma. The route permit is Garacharma bus stand to Garacharma. Now you know whether the Amber Bar is within Garacharma or outside Garacharma, that has not been clear. But it is mentioned Garacharma. If Garacharma is mentioned, we have to take in a beneficial manner only. Because unless and until the other side proves that Amber Bar is beyond the Garacharma or beyond the PPS, what they are saying, then in that case, the matter would be different.
Yes.
But here they were unable to prove that Amber Bar is located beyond the Garacharma or PPI scheme. That they were not able to establish.
Very.
So owner is not responsible.
Response number 2 is concerned. The other side is stated that it was 3,000 rupees as notional income. There is no document to show that it was 3,000. Let them show any document that it was 3,000 rupees. There is no any document. So, to my understanding, 6,000 what has been given by the trial court is right in all respects. Multiplier, I do agree, it is not 80, it is 70.
Personal income has to be seen as per the table.
He was a young boy of 28 years, and these two petitioners, these two claimants, they were minor at that time when he expired. So mother was dependent upon the elder son, and elder son was all other children were dependent on him.
What is the occupation of the deceased?
He was a
Auto driver.
Where it appears? So it is admitted that he was the auto driver. Very well. Yes, anything?
Just one thing I would add. So the other side have said that there was a issue with regard to the route. Not route kindly turns to the page 87 of the paper book. The tribunal have adjudicated this issue. So kindly see in the manner it has been recorded. 87, 3 line from the top. There is no other cogent evidence on record on behalf of the booking number of the insurance company to establish that the offending vehicle willfully violated the condition. So they have taken this stand in one line, but the tribunal have decided it. There was no concrete evidence before the tribunal to hold that the owner was not holding a valid vehicle. There's no violation as such. But as regards to this multiplier 80 in lawsuit, I say lawsuit the tribunal has rightly applied 80. Age was 28. It was rightly applied. I'm not.
It was 28.
28. It's recorded. I'll show. Page 88. Page 88.
Where is the
Page 88.
no page 88?
88. Last 3 lines from the bottom.
No, where is the PM?
But yes, no. Just one. 28.
Show me the PM.
Yes, page number 2, you are page is here. They are doing petition. It is their own claim.
We may say wrong also, but document may not. We
Yes,
should also-
yes. Show me the PM.
28 years.
20.
No, that is wrong. Madam. Not 20.
It's a conclusive document as regard assessment on the age. And even the tribunal has decided this issue, that he was 28 at the time of when he succumbed to injury. What can find it page 88, last three lines. 18 multiplier is a reasonable one. It is a statutory multiplier. Right? It has been put in.
25 to 30 is 18.
Yes.
Yes, yes.
25 to
Yes, yes.
30 age group is the 18.
Yes. Yes, sir.
And PM says it is 28 years.
My lord.
28.
When the tribunal has considered this aspect, not at page 88, last three lines. While awarding future prospectus, adjudication has been made. Now should we find
Yes.
28. So in the light of the aforesaid judgment, this tribunal is of the view that the victim aged 28 is also entitled to 40% additional income for his future prospectus. Look, it's not a case of disablement, lordship, partial disablement. It's a matter of death. These COVID and all, lordship, these issues should not be raised. Lordship, we are the dependent members. The order may not be interpreted. Yes, the order may not be interpreted, lordship, in any manner. Summary prayer.
Their own document will show that age is less than that. Page 28. Family ration card is there.
Lord knows in the family ration card what we say that is being recorded. But PME is the conclusive document.
No.
Yes,
Not
yes.
conclusive.
He may say wrong, like you have document has recorded, but that cannot be taken to be a sacrosanct.
Serial number 3, 20 years.
When it was prepared?
Yes, 2003.
Death occurred, no Lord.
2003. Their own claim petition says that it is 23 years.
A poor drafting, Lord, I would say. It's a
Yeah,
poor drafting.
poor drafting.
But one should not be scuttled on that ground. More particularly, it's a motor accident claim. Death occurred.
It occurred because of the negligent driving of the.
No, those things have not come out.
It is there, it is there.
You not demonstrate these aspects. These things have not come. It's a very argument being advanced for the first time before this.
No, that was taken.
Pranay Shetty is very clear, Lord, on that issue. Everything has been decided with Pranay Shetty, Lord. The same ratio has been applied while deciding our claim application, Lord. And we all would pray, Lord, with older acts, no interference.
Personal expenses also 50% was. As to 50% has to be taken into account. 1/3 was taken into account.
Page 87 last and 88 first. The observation of tribunal is there. Regarding the age. Right.
We pray, Lord, we have not taken out the cross appeal. We may pray, Lord can grant under this jurisdiction enhancement of interest. We have not taken out cross appeal. 6 persons have been awarded. It can be done.
No, you can't.
Without taking order 41 to 22 appeal, cross appeal, I can interest, Lord, it's very less. 6%.
You are not.
Beneficial legislation, Lordship, Lord can understand. It's not that, Lordship, under the Motor Vehicle Act, Lordship, and particularly this court having the jurisdiction, constitutional jurisdiction can, as so far as the interest part is concerned, I would leave pray.
Interest was given 6%.
More.
No appeal was
In that case, have calculated.
No appeal was filed.
In 2003, he was 20 years of age, and he expired in 2010. So exactly 28 years. In 2003, he was 20 years of age.
There is a decision of Sunita by the division bench of this court regarding the enhancement of compensation without the filing of the cross appeal. Okay, there is a specific direction in respect of interest.
Interest.
Yes, in respect of interest, it cannot be enhanced. Okay, this is the division bench decision of this court, headed by Justice Deepak Gupta.
We vote. No interference may kindly.
Now, 50% has to be there.
50% has to be there. Age has to be calculated as 28.
Okay, here. Please take down. The instant appeal has been preferred by the insurance company against the judgment and order against an award. No, cut. Against an award dated 8th of October 2021, passed by learned MSC Tribunal, MS Motor Accident Claim Tribunal, Andaman and Nicobar Islands, in MSCT case number 2 of 2012. Stop. The brief fact of the case is that the present respondents, the mother of the present respondents has preferred an application before the learned tribunal under section 166 of MV Act for getting compensation on MV Act for getting compensation on the ground that the son of the claimant was died in a road traffic accident due to rash and negligent driving of the driver of the offending vehicle, duly insured under the policy of the insurance company. Stop. Next para. The claim case was contested by the insurance company, and after hearing the parties and after taking the evidences on record, the learned tribunal has awarded a compensation amounting to rupees 12,19,600 in favor of the claimant, along with 6% interest per annum from the date of filing of the claim application. Stop. Being aggrieved by and dissatisfied with the said award, the insurance company has preferred this appeal. The learned advocate for the insurance company submits that the income of the deceased was not proved before the learned tribunal by adducing any sufficient or cogent evidences. Thus, according to the decision of Sarala Varma, Sarala Varma, SARLAVARMA, it will be capital. Sarala Varma, the notional income of rupees 3,000 per month has to be adopted in this case. Stop. The tribunal has erroneously assessed the income of the deceased to be 6,000 per month. 6,000 per month without any basis. Next para. He also argued that the multiplier adopted by the learned tribunal is erroneous. It should be 17 instead of 18, considering the age of the deceased as mentioned in the claim application to be 23 years. Stop. Next para. He further argued that the 1/3 of the compensation was deducted towards the personal expenses by the learned tribunal. Stop. The deceased was a bachelor, so in this case, the personal deduction would be half. 1/2. Stop. Next one. It is the further case of the appellant that the offending vehicle had no valid route permit at the time of accident. At the time of accident. Stop. The driver of the offending vehicle has plied, PLYD, plied beyond the route permit and caused the accident. Thus, the insurance company is not liable to pay the compensation. Stop. In this case, the owner of the offending vehicle may be liable to pay the compensation. Stop. Learned advocate, next part. Learned advocate appearing on behalf of the claimants submits that the learned tribunal has committed no error in passing the impugned award. Stop. The learned tribunal has specifically observed that the deceased was a auto driver. Stop. Though the claim was made to submit the income of the deceased to be 20,000, but the income of the deceased was calculated by the learned tribunal correctly to be 6,000. Correctly to be 6,000 per month. Stop. The applicability of notional income system is in a case where there is no proof of income. Stop. Next para, it is also submission of the learned advocate for the claimants that the deceased was within the deceased was aged about 28 years at the time of accident. 8 years at the time of accident. Thus, the learned tribunal has correctly observed that this is observed that the applicable multiplier is 18 according to the decision of Sarala Verma, followed by Sarala Verma, followed by Pranay Sethi, PRANAY ACTHA. Stop. Next part. The claimants, however, admitted that the deduction part on behalf of personal expenses would be 50%. Stop. Next part. Learned advocate for the owner submits that the accident which happened in the Garachama. The offending vehicle had the permit to ply the vehicle at Garachama. To ply the vehicle at Garachama. Thus, the terms of the agreement along with the owner and the insurer has not been violated in this case. And stop. The accident happened within the route permit. Happened within the route permit of the offending vehicle. In that score, the owner of the offending vehicle is not liable to pay the compensation. Stop. Next para, are the learned advocates peruse the impugned award passed by the learned tribunal. It appears that the deceased was a private auto driver. Stop. It has been stated in the claim application that deceased used to earn rupees 20,000. Stop. It is true that no evidence, whether oral or documentary, were advanced by the claimant before the learned tribunal. Stop. Learned tribunal has decided the issue of income of the deceased and is of opinion that 6,000 per month would be the correct income of the deceased. In considering the submission of the learned advocate for the insurance company, comma, it appears to me that the notional income ratio is laid down by the Honorable Supreme Court in several judgments, finally in Sarala Verma. Stop. Stop. It has been assessed by the Honorable Supreme Court that in case of a daily labor and a person who don't have a specific and a person who don't have a specific income or occupation, it is fixed that a person may earn rupees 100 per day. On that score, the notional income was fixed to, on that score, the notional income was fixed to be 3,000 per month. Stop. In this case, the deceased was a auto driver. Stop. Being an auto driver, he was employed in a specific occupation. Stop. In that score, the fixing of notional income in respect of the instant deceased is not applicable. Is not applicable. Instant deceased is not applicable. Considering the present fact and circumstances, I am of a view that the learned tribunal has observed and had the opportunity to look at the entire merits of this case. Thus, in my view, the income of the deceased, which was fixed by the learned tribunal, appears to me correct. Stop. It is true that it is true that the claimant has filed the claim application stating the age of the deceased to be 23 years, but the learned tribunal has observed the PM report wherein the age of the deceased was stated to be 28 years. Stop. The ration card also indicate the age of the deceased to be more than 25 years. Considering the same, I think it necessary. I think it fit to observe that the learned tribunal has correctly applied the multiplier 18 in this case, considering the 18 in this case, considering the age of the deceased to be 28 years. However, next part, in this case, the personal reduction would be 50% instead of 1/3. Next para. Considering the FIR in this case, it appears to me that the place of occurrence was stated to be near Ambarbar, AMBORBAR, Garachamma. The DW1 deposed that the offending vehicle had the route permit to ply the vehicle from Aberdeen Bazaar to Garachama TTE College. Stop. Considering the evidence of DW1, it appears to me that the accident happened within the route permit of the offending vehicle. So there is no violation of terms of contract with the insurer and the owner of the offending vehicle. In that score, I am of a view that the insurance company is liable to pay the compensation. Compensation. Stop. Considering the entire matter, I think it necessary to modify the order of the learned tribunal, observing the fact that the learned tribunal has passed the judgment, passed the award by virtue of the decision of the constitutional bench of Honorable Apex Court, passed in Pranay Sethi. Pranay Sethi. Stop. Next part. Stop. The constitutional bench. Next part. The constitutional bench of the Honorable Apex Court has observed that in case of a deceased who was self-employed, who was self-employed and within the age below 40 years, the 40% of the established income should be added towards the future prospects. Added towards the future prospect. Stop. The Honorable Apex Court also observed that the general damages would be 70,000, including the consortium of rupees 40,000. In this case, consortium of rupees 40,000. In this case, the present deceased was a bachelor. So,
That was 100 months. Page 88 it is there. That's why.
yes, 40% future prospects was added. But where is the general damages? General damages would be
In this case, this is one.
deceased was a bachelor, so the claimants are entitled to get the general damages of rupees
Entitled to damages.
of rupees 30,000. Stop. 30,000. Stop. Next part, it has been argued by the learned advocate for the insurance company that the instant claim application was preferred by the mother of the deceased. Stop. The mother of the deceased, the claimant died during the pendency of the claim case, and the present opposite parties are the brother and sisters of the deceased. Stop. According to the provisions of section 166 of MBA, the legal heirs are entitled to get the compensation according to the provisions. According to the provisions of the Act. Stop. Considering the same, I am of the view that the present claimants, being the brother and sister of the deceased, are within the class 2 heirs of a Hindu. Oh, they are the Mohammedans. Mohammedans. No, they are within the sharers. Within the sharers of according to the Mohammedan law of inheritance. So they are entitled to get the compensation according to the law. In 50%. In 50% each.
Grateful. Shariat law has come into picture, and then I'm afraid daughter
Yes. Next part. The strict compliance of the Sharia Act has not been strict compliance of the Sharia law. That is the brother would get the double to the sister would not applicable in the case filed under section 166 of MBA. Stop. Under section 166 of MBA. Stop. It is necessary. Next part. It is necessary to recast the just and proper compensation of this case. Stop. Stop. Next paragraph. Give me the calculator. Give me the calculator. Do you have the calculator? No, you don't have. Open the calculator. Monthly income. 6,000. Yearly income. 72,000. 40%. 40% is to be added towards the future prospects. 40%. So 72 to 40%. 72. So 28,800 is added. 800 is added. So after such addition, it appears 72,000 plus 28,000. 8,800 plus 72,000. 1,08,800.
It appears
1,00,100,800. Full stop. Stop. The 50% of which is deducted towards the personal expenses. So it appears to be 50,400. 50,400. Applicable multiplier is 80. Multiplier is 80. So after applying the multiplier, it appears to the award comes to rupees. In the multiplier, the award comes to rupees 9,07,200. 9,07,200. Full stop. The claimants are entitled to get the 30,000 and 30,000 towards the general damages. Now the award comes to rupees 9 lakh. No, comes to rupees 9,37,200. 37,200. 200. Whether you have awarded anything? No. Have you paid anything? No, nothing has been.
only 5,000 we have deposited to the registry.
Okay, registry. Only 25,000.
At the time of filing the appeal, that is to be returned to us so that we can disburse the.
Okay, okay. So you have.
was 25% of the total amount. Simply deposit 25,000.
No, I understand.
25% has to be. But they deposit-
Very well, very well, very well. No issue.
It's not my.
No issue, no issue, no issue, no issue.
My choice.
Very well, no issue.
40% of the future prospect.
Yes, that is added. So the insurance company. Next particular. So the just and proper compensation comes to rupees 9,37,200. 200. Stop. The insurance company is directed to pay the compensation to the claimant along with 6% interest per annum
My lord, the
from the date of filing of the claim application.
COVID period. sir.
All suffered in the COVID period
Yes, I'm grateful.
from the date of filing of the claim application. From the date of filing of the claim application. Within
But till it's finally paid, madam.
no,
Till it's
within 8 weeks
I'm grateful.
or the 8 weeks from the date of passing of this order through which
First,
office?
we check before the
Before the tribunal.
trial court.
Okay, before the tribunal, through the office of the learned tribunal. Stop. On such deposit, the claimants are at liberty to receive the same. No, what is the procedure? Whether they file the check,
The insurance company will deposit 2 checks. sir.
okay,
Divided.
Because they done at court below.
I understand.
Also, deposit the claimants
Are at liberty to receive the checks in their favor according to the prevalent rules. Stop. The next part, the insurance company has deposited the initial amount of rupees 25,000. The initial amount of rupees
In terms of the order passed on.
25,000 with the registry. With the
17th
registry.
January 23.
They are at liberty to, no, stop. The same amount must have carried some interest. The insurance company is at liberty.
Registry may be directed to return the same. money.
Yes, I am directing.
the same amount must have
Carried some interest. The insurance company is at liberty to receive the same from the registry.
No, but just one indulgence. no. If it is not paid within the time limit, the tribunal must fix 8%. 90 days, not kindly see the last
That
line.
will follow.
If it is not done within the time which this court stipulates now, then the interest has to be at the rate of 8%.
No, they are paying. Whether there is any flaw like that,
No, kindly see the tribunal. order.
I understand.
No. If they don't pay within the time, if they do not deposit or they do not pay, then the interest part, 6%, tribunal has given it, it's 8% after 90 days. Some enhancement if it is not within time.
No, they are paying. No, you are not paying.
If they not pay, or if they may.
I never seen such a circumstances that the insurance company is not paying after the order of the High Court. It would be paid. No issue.
Only one submission. One's name will be added.
Yes. You give me the name. You give me the name. I
If I don't give her name, then it will be problem in my house.
yes. Miss Anita Hegde is there. No issue. Accordingly, the FMAT is disposed of.
Please,
Yes.
I'm grateful.
Public.
That's-
Next,
Item number 2, there are 11 of 123.
Lord, I'm there for the petitioner husband. Not you, I'm responding to the right.
I appear to be state.
Lord, everyone, Lord, respect human. I don't dispute it. But this is one of such case where the wife have left no stone unturned to extract more money from the husband in a proceeding which is not tenable in law. The challenge in this revision application is to an order passed by a family judge in a proceeding under section 125 CCRs. Lord, the original proceeding at the behest of wife ended with the intervention of mediator. 10,000 was about. This could dispute, no challenge. It's again finality, I'm paying it. The point is, Lord, the wife, before the present proceeding could be taken out, that's in this case 77 of 2021. In the past, she has filed proceeding under 125(3) on several occasions. I have annexed those petitions. Lord, the period for which the family court in the last proceeding ordered covers the amount which has already been paid, because those proceeding on full satisfaction disposed of. That's one point. I have given the entire chart before the family judge that the amount which they claim in the present proceeding which are challenged, that's miss case number 77 of 21, have already been paid in this case number 76, 74, 75. But this calculation in a proceeding under section 125(3) is very tricky. No one can easily land it. A sitting is required. But I have set across the table with reference to papers showing that I paid the amount. Those papers were placed before the court, and attention was drawn that this amount for which they are claiming the amount has already been paid. The court has turned down. This first point to challenge. The second is about 125 proviso. Rather, I would say, I'll just draw laws. It can be invoked within certain time limits. That's 1 year. I'll just show that.
Yes.
No, the proceeding one which has been taken out in which these orders were passed is beyond 1 year. So mainly on these two counts, because I'm regularly paying. I'm a government servant. I'm regularly paying. The procedure as required for levy of fine has been those things I don't argue much. But my point is mainly on these two counts the order cannot be sustained, and I've sought for quashing of those ones. I'll just refer to few papers. Kindly see page 30. Now is in criminal revision reappreciation of evidence document. I have to show that the orders have really shocked the conscience of this court. Yes, that is the criteria. But page 30 is the first miss case 75 of 21. This relates to the period. I'll just show in the prayer.
No, you have challenged the order dated 7/7/2023 in mis-execution case number 58.
No, 58, yes. Sure. By virtue of which lordship, a distress warrant was directed. Well, can it come to that order once not 107, last election, immediately before the Wakalatnama? May I place the order?
Yes.
Sure. It's order number 8 dated 7/7/2023. The case was fixed to this date for hearing of the petition dated 6/7/2023, filed by the respondent then after for the petition for the sake of convenience. In the petition, the respondent inter alia states that as he has paid the amount claimed by the petitioner, this proceeding should be dropped. The said petition was taken up for hearing this day. Learned advocate on behalf of the petitioner was present and submitted that the petition being frivolous should be rejected as the payment mentioned in the petition are not related to the claim of this petition. The petitioner has filed written objections supported with an affidavit to the said petition, and a copy of the same has been served upon the respondent. None appears on behalf of the respondent on repeated cause. Third, letter advocate on behalf of the petitioners furnish the petitioner other material records. At the outset, it is to be stated that this case relates to recovery of arrears from the respondent of monthly maintenance allowances at the rate of rupees 10,000 per month from 1/8/2021 to 31/7/2022, amounting rupees 1,13,500, as rupees 6,500 has been by the respondent on the basis of mutually agreed settlement between the parties on 25/7/2019 before the mediation cell Andaman Nicobar Island Court there. It is to be stated that the recital as mentioned in the petition filed by the respondent is not supported by an affidavit whereas the petitioner on oath has contradicted the said recital of the respondent on oath. On bare perusal of paragraph 3 of the petition, it appears that the interim maintenance money received from 22/8/2017 to 10/3/2021 are enclosed with the petition. It is pertinent to point out that this case leads to recovery of arrears of monthly maintenance allowances at the rate of rupees 10,000 per month from 1/8/2021 to 31/7/2022, amounting rupees 1,13,500 as detailed above. In other words, from the petition, it is clear that there are no money receipts to show that the respondent has paid the said legitimate dues amounting rupees 1,13,500. As the respondent has failed to show money receipts with regard to the claim of the petitioner in this proceeding, the petition being produced merits no consideration, deserves to be rejected on account of the aforesaid mentioned reasons under the facts and circumstances of the case to meet the best interest of the justice. Hence, order the petition dated 6/7/23 filed by the respondent is duly considered and rejected. as the respondent has not paid 1,13,500, which are legitimate due of the petitioner who is in a state of penury, it is necessary to issue distress warrant against the respondent for realization of the said legitimate dues of the petitioner from the respondent. The case is 6/9/8/2023 for the execution of the distress warrant. The petitioner is likely to file requisites immediately, preferably in course of this date. Now, this proceeding was lodged. I'll just give the date. For kindly see the first order on 6/9/2022, which is beyond 1 year as mandated under 125. This way, this cannot be allowed. Not one has to be vigilant. No, I understand. My wife, if this proceeding is pending, I have to pay. There's no escape. But this way, husband should not get rest. As and when she thinks, she comes with an application. This was the fifth proceeding, I would say, that this case 58 of 2022. In the the date. Dates are crucial. So my first point of argument, I'll just refer more to 153, 125.3. For 125, just I'll take plus to 3.
So when the application was filed, Miss Case, 6/9/2022.
22. 6, the first order, 104, page number 104 mechanisms. This case number 58 of 22.
Yes.
So as I've started my argument with this pronunciation, I have a great respect to the wife. I am paying it. But this way, Lord, I am a government servant working as a peon. Pressure is being inflicted. On and off, police personnel come to my home for ascertaining the details of movable property. Over time,
Yes.
125.3.
Yes.
I'll straight away go to 3 months and it's provided. If any person so orders, fails without sufficient cause to comply with the order, any such magistrate may for every breach of order issue a warrant for levy of amount in the manner provided for living fines and may sentence such persons for the board or any part of each month allowances for the maintenance or the interim maintenance and the expense proceeding as the case may be remaining unpaid after the execution of warrant to imprisonment for term which may extend to 1 month or until payment is sooner made. So why so? Provided that no warrant shall be issued for recovery of any amount due under this section unless application be made to the court to levy such amount within a period of 1 year from the date on which it became due. To expatiate, the proceeding cannot be sustained. No warrant can be issued. This warrant cannot be issued. But I have on affidavit before the family court in this proceeding as
No. What is your submission?
my submission is Lordship.
So it has to be filed within 1 year.
1 year from when the amount is due. Madam. The due amount, the date needs to be seen. In their application, the due, when is the date due? That is the point where everything comes into a standstill. That point is to be considered to be the date for the wife petitioner seeking a benefit under 125(3). If it is beyond 1 year, it can't be done. For better understanding of this proceeding, the preceding orders, a preceding proceeding needs to be seen because the amount which they claim 1,30,000 has already been paid. Those proceedings, 4 proceedings, back to back they file has been disposed of on full satisfaction. Current rate of payment I'm making it. But every penny is counted. I mean, government servant person. Every penny is counted. I understand 125 scope is very limited. Husband has to pay, no escape. I can those things. I'm conscious of this fact. But at the same time, husband is entitled to protect his money also. Not the way this has been claimed with the wife. This is my first point. But when I said
1st August 2021 to 31st July 2022.
Yes,
This is the claim period.
claim period, yes. Check period, I can say, my lordship.
Yes.
It's a check period.
So, what is your submission? The application has to be filed within the 1st August 2022.
Absolutely, absolutely. This is my understanding to this provision. I literally do not do criminal matters, but I think that my mind has said that this is what I have understood, subject to what my lord says. Subject to what my lord says. This is one aspect. Secondly, when I have said this thing on affidavit, that's the point. Before the family court on oath, it's not that I have said simply on affidavit enclosing all the documents that for this period they have not used a counter affidavit.
No, you have not filed any document. They have, it is the order.
On an affidavit. The
No,
receipt showing payment of the amount which they claim in this case, 58 of 22 is by way of an affidavit. The court has recorded this fact.
no, the court has observed that you have not filed anything, receipt like that.
Just one second. I'll just show that. Just one second. Order number 7 may kindly be seen. The preceding order. Order dated 6/7/2023. It files a list of interim creditors received by the petitioner to the respondent for the period of money received are enclosed here along with the petitioner. The list has been filed with the bank statement for this period.
That means you have paid.
Yes, but the court by order impugned is guided by a normal principle that wife is always true, husband is not. This document, when such situation comes, the court has to be more cautious, not. As I've been saying, it's a matter of every penny it's counted. At least, Lord, 6/7/2023, the case was fixed. On 7/7, it was decided. It's a matter of calculation, Lord. Particularly when in the present case, in the given case, I've said the amount has been paid, but not kindly see the earlier proceedings, 4 proceedings, back to back, we have filed. I'll just show that. But I'll write from page 13. The first proceeding was this case 75 of 2021, page 13. I'll just show one way. This needs to be shown. Not this was shown before it.
No. Let me clear out the issue. Whether you have received, that is the issue.
That is complete not then I will give a follow this. No, they would normally say it has not been issued. Now I'm going to support with this material, with this law. This has to be, otherwise the position would remain. So long, even if I get a divorce, even if she do not marry, she has entitled. Wife is entitled. I don't dispute it. Law is made with such a action. I cannot dispute it. I have to pay. There's no escape.
No, you are firmly saying that you have paid it,
Yes.
and they have also firmly said they have not received. How can it be done?
But in such a case, the court should have taken aid of an expert.
Yes,
If I'm saying one thing, the other side is dealing with it.
yes.
There has to be a calculation from a concreting part that has not come. The court said, no. Wife said, you have to pay. Because she's in the state of destitute vagrancy. Because why I'm saying not? Because warrant has been issued, district warrant had it been a 50-second order, I could have understand. I'm a government servant, police on and off comes to my, I do not want to repeat those things again. Or one thing can be done, my lord, subject to my lord's saying, even at this junction, this can be taken up Monday, Tuesday, Wednesday. Any expert, chartered accountant, anyone who is expertise in this field, with certain guidelines in an order to calculate it to place a report. Within this circuit, I want this matter to be decided.
Yes, what is your submission?
But if I need 10 minutes from this application only, this can be rejected with cost. Lordship, this instance here is a classic example how a husband makes harassment to his wife and makes the wife escape criminally. Lordship, kindly appreciate it is saying that I have filed 5 resolution case. Lordship, the petitioner hearing has no respect for the honorable court order, honorable standing court order. As such, for the recovery of every area's amount, I need to file an execution case. For that, I have filed 5 resolutions, Lordship. Miss Resolution 75, 76, 77, 78, and 58 of 2020. The mixed execution 75, 76, 77 and 78 were disposed of only when a warrant was issued, and after that they did not do anything. They have paid me at last. Lordship, in case number mixed execution case number 58 or 23. Lordship, my areas of amount is from 1/8/2021 to 31/7/2022. Lordship, 125(3) says tightly 125(3) provided that no warrant should be issued for the recovery of any amount due under this section unless application be made to the court to levy such amount within a period of 1 year from the date on which it becomes due. Lordship, my page number 44, Lordship. Lordship, I have filed this case for a period of 1st of August 2021 to 31st of July 2022. I have filed on 6th September 2022. Lordship, had I filed after 31st July 2023, I would have been barred by 125(3). It says for the period it becomes due. 31st July 2022 is the period, and I have filed in September 2022. I am way inside the limit. Had it filed after 31st July 2023, it should not have been applicable. First line, it is 100% applicable. Second point, Lordship. Lordship, they have filed one application that they have paid the entire amount. Page number 48, Lordship. They filed an application that they have paid the entire amount, so this instant execution suit should be dropped. Lordship, in the first page, serial number 8, kindly Lordship, take the serial number 8, the 7/7/2022 6,500. Apart from that, from serial number 1 to 7 are the payments made before that period that for which I am harping upon, and from 9 to 23 is the period that has already elapsed. Lordship, on serial number 8, 6,500 has been paid. Lordship, an amount of 10,000 needs to be paid to me. Yearly, he needs to pay 1,20,000. 6,05,000 he has paid. I have filed this execution here 58 of 22 for 1,30,500. All the rest payments are before and after. And Lordship, the list of on page 49, Lordship, 49. There is another list which says list of interim maintenance money received issued to the previous respondent that are all from 2017 to 21. Lordship, kindly appreciate I have not filed the instant execution case for this period. Just imagine, Lordship, they have what they have done. They have shown the payments that they have made me. They have shown the payments that have made in 75, 76, 77, 78, and they have taken all the receipt and filed with this. The Honorable Family Judge has rightly seen this and rejected the Lordship. After that, there are lines of receipt 53, 51 are all the receipt of 2020, 2022 and all they have filed. Kindly see, Lordship. Receipts. Page number 51 are the receipt of 2020. I am asking payment of 2021 and 22. Lordship, like this, all 52, 53, 54, 53A, 54, 55 are all receipts, which has no value to this instant execution case. Not at all related. And this has been categorically caught red-handed by the Honorable Family Judge.
Now, what is the page 53, 22?
Yes, Lord. He's keeping these documents.
Yes, Lordship. Yes, Lordship.
So 22.
All are,
Lordship, 53.
all are of 22.
Yes.
Lordship. My
54.
Lordship, can you see my period? 1/8/2021 to 31/7/2022.
Yes,
Are any of the receipt of this period, Lordship?
this is of August 22. One is August of one is September. One is July 22.
Lordship, I have got 31st July 2022, and these are all. Sir, Lordship, this is September. I am asking up to September. I am asking up to July 22. This is September. This is August. This is September. Only one receipt 6,500 rupees that I have already said that they have paid. That's why I have claiming 1,13,000. On the top, with lordship.
The order is cryptic, lordship. There has to be a finding in a proper way.
Lordship, kindly-
11 November, October 22 has been paid.
54.
Lordship, my amount, I am claiming up to 31/7/2022, up to July 22. And these are amount which have been paid in that execution case, 75, 76, 77, 78. These are not related to this case.
How that can be?
Okay, how can you say, sir?
How that can be?
No, it has to be assessed like that. What is the due till today and what he has paid till today? This is the issue.
Lordship, we have not paid any amount in this instant execution case, 58/8/22. That's why the honorable court, Lordship, kindly appreciate, Lordship. And Lordship, after that,
So who assess it that it was not paid?
I'm grateful.
So why this period the payment was done and you have received it?
Lordship,
That may be the earlier payment.
yes, Lordship,
That may be the recent payment, current payment.
that payment, Lordship, in an execution case, when any payment is made before the honorable court, a receipt needs to be filed. That I have paid this amount, you file a receipt. In the instant execution case, the order which they have challenged, there are no payment, there are no receipts that they have stated payment, and there is no receipt, Lordship.
Okay, very well. You file it on affidavit.
Yes, yes.
What is the due till today regarding these periods? Okay, what is the due? And you also file an affidavit that what you have paid.
Yes.
File on affidavit, I will decide.
Yes, let me complete one thing. Let me complete. Lordship, page number 64. Page number 64 is the interim maintenance application which has no relevance in this instance case. 68 is also the same. 69, 70, 71, 72, and also these are the mis-execution of 94 of 16. Some mis-executions name are also not there. These are all of 2018. Thus, these all have any resemblance with this instant execution case.
No, it is this, it has been deposited that he is paying. This is the only submission, not in respect of these matters.
They have been paying only the regular maintenance amount.
Very well. Yes, you have to file an affidavit to the effect.
Only
You have also filed affidavit on Monday.
Only one thing like on Monday. Page number 89.
Now, what you want to show?
Lordship, they have filed one application to drop this instant execution that they have paid. Lordship has said me to file an undertaking. The same in WO I have stated. Page number 89, paragraph number 2. Paragraph number 2, that the contents of paragraph 2 opposite parties on opposite parties recovery of amount of maintenance from 1/8/21 to 31. Petitioner further submits that the petitioner has not received any payment from the opposite party in the present case, and the money received and the bank deposit pay slip which the opposite party has filed before the honorable court.
Yes, very well. You file affidavit, I will pass a necessary order by appointing one special officer. Okay, if that be done, the necessary strict order would be passed against the petition. Okay,
Kindly appreciate in order of family death. From the day one, I filed this case in September 22. And from September 2 up to July, they have taken adjournment. And after 1 day, they've taken application.
I know the situation.
All the receipt, I say I have paid. How can this loss be?
Very well, I know the issue, what they have taken, I know the stand also. I know. So please take down. The learned advocate of the petitioner and the opposite parties, private opposite party, is directed to file an affidavit showing the payment whether made or received by the respective parties for the relevant period of, what is the period?
I'll just give it there.
From 1/8/2021 to
Yes.
31/7/2022. They must furnish the affidavit
Along with documents.
along with certain documents, if any,
Fine, great.
if any. By 16th.
Obliged.
By 16th. Appear on 16th.
Item number 3. Item number 3.
Lordship, I appear for the petition.
2022.
And I am for the state respondents, my lord.
Yes.
So far as the prayer number 2 only can be considered right now,
Lordship.
because for representation, prayer number 2.
I'm pressing on that. Prayer number 2 only, let them consider my representation dated 17/12/2021. Lordship. Let them consider my representation with reasoned order. Dispose it of within a time bound manner. Lordship, the representation, it appears on page number 21 and excerpt P3.
Seventeenth of December,
Lordship, my lord.
2021.
Lordship.
That is the respondent number 2 is the authority,
Respondent number 2 is the authority, Lordship. The
executive
executive-
engineer.
Lordship.
He is the authority or
Both 1 and 2, both.
Both
Both
one
one
and
and
two.
two.
Specifically, it was addressed to.
very well. Respondent's authority, I am sorry.
Fine, deep reparation.
Please take down. The instant read petition was filed by the petitioner seeking necessary direction upon the respondent authority for immediate release of the final bill. Stop. It has been submitted by the petitioner that the representation of the petitioner dated 17th of December 2021 was not considered by the authority concerned. On considering the submission of the learned advocate for the respondent authority, it appears that the authority must have to take the decision promptly. Stop. Accordingly, the instant writ petition is disposed of with a direction upon the respondent authority to consider and pass a reasoned order in respect of the representation of the writ petitioner dated 17 December 2021 within December 2020,
Well,
within December 2023.
Deep reparation.
After awarding a reasonable opportunity of being heard to the writ petitioner.
Deep reparation.
After arriving at the reasoned decision, the respondent authority shall inform the decision to the writ petitioner within a fortnight thereof.
Highly reparation.
Accordingly, the writ petition is disposed of.
Highly reparation.
well, let there be a line be added that this writ petition has not been disposed of in merit since no affidavits are called for.
Okay, as no affidavits are, no affidavit of opposition is called for. So the merit, the allegation contained in the writ petition is taken, is deemed to have been shall deemed to have been not admitted, and the learned and this court has not gone into the merit of this case, and the concerned authority has to take the independent view without being influenced by the any order of this court.
Deep reparation.
Without being influenced by any observation of this court. Next.
Item number 4,
Same it is.
Lordship,
Same
similar,
order.
similar,
Similar
similar,
order.
similar prayer. Even the
Date.
representation date is also same,
Representation is also
17/12,
same.
2021.
Okay. Same order, within December,
Deeply obliged.
same order.
Item number 5, BRR 20 of 2023.
Lord, I make my appearance for the opposite party respondent. We both had a talk, Mr. Binu Kumar, who appears for the petitioner. This can be taken up on Monday. I think Monday.
Very, not today.
Not today.
Item number 6, CO 54 of 2023.
Lord, I represent on behalf of the Lord petitioner, Lord,
Yes,
who is the defendant in a suit for partition.
yes.
Now, Lord, partition decree was passed in between the parties, preliminary partition decree, thereafter final decree was passed. Now, Lord, during the period of after the final decree, proceeding under section 47 was drawn up, several proceedings initiated, 47 initiated, rejected High Court. Lord, after all, Lord, at the intervention of some well-wishers, my Lord, the parties have settled amicably settled their dispute with regard to the adjustment of the decree. Now,
Yes,
Lord, I file an adjustment of the decree. Now, Lord, after the adjustment of the decree was executed, Lord, by the decree holder, Lord, both are in a partition suit, both are degree holders. By the degree holder, Lord, it may be said to be a judgment data, loosely to be said as a judgment data. But, my Lord, after that, my Lord, we file an application under Order 21, Rule 2 of the Code of Civil Procedure. Lord, Lordship, kindly come to my application, what we have stated, that adjustment has already been made between the parties with regard to the final decree. And, my Lord, a certificate may be granted in favor of the petitioner. Lord, that provision, my Lord, previously this provision was restricted to a money decree. Lordship knows that. And after the amendment of 1976 Amendment Act, Lord, then any kind of decree can be adjusted by mutual convenience or mutually by the parties. Now, Lord, your Lordship, kindly come to Order 21, Rule 2 first.
the CPC.
Civil Procedure Code, my Lord.
Yes,
Lord, where any money payable under a decree of any kind is paid out of court,
no,
then or the
order
decree
provision,
Order 21, Rule 2, my Lord.
order 21, rule 2,
Rule 2.
order 21, rule 2.
Lordship got it.
Payment out of court.
Here, where any money payable under a decree of any kind is paid out of court, or the decree of any kind is otherwise adjusted. Lord, this has been amended in 1976. Or any decree or the decree of any kind is otherwise adjusted in whole or in part to the satisfaction of the decree holder shall certify that such payment or adjustment into the court whose duty it is to execute the decree, and the court shall record the same accordingly. Then the judgment debtor of any person who has become surety for the judgment debtor also may inform the court of such payment or adjustment and apply to the court to issue a notice to the degree holder to so cause on a day to be fixed by the court why such payment or adjustment should not be recorded as certified. And if after service of such notice, degree holder fails to show cause why the payment or adjustment should not be recorded as certified, the court shall record the same accordingly. Then, my lord, no payment to A, no payment or adjustment shall be recorded as the instance of the judgment debtor, unless the payment is made in the manner provided in Rule 1. B, the payment, Lord, my case, to A, B will apply. The payment or adjustment is proved, Lord, or adjustment is proved by documentary evidence. Now, Lord, documentary evidence, Lord, duly signed by both the parties, agreed, and then the payment or adjustment is admitted by or on behalf of the decree holder in his reply to the notice given under sub-rule 2 of the Rule 1 or before the court. A payment or adjustment which has not been certified or recorded as aforesaid shall not be recognized by any court executing the decree. Lord, long thereafter, the degree holder himself file a suit, challenge admitting the adjustment, but challenging that adjustment, Lord, by filing a suit. Now, Lord, on the ground of fraud, undue influence, Lord, your Lordship knows, Lord, in our, Lord, when we are a law student, we knew for everybody that if it is challenged on the ground of section 16, 18 to 22 of the Contract Act, Lord, then unless it is avoidable contract.
Yes.
According to the degree holder, it is avoidable contract. Now, Lord, it is not a void contract because unless, Lord, a voidable contract is declared by a court, it valid remains. Under the law, my Lord, it valid remains. Now, Lord, he challenged it. Now, Lord, your Lordship kindly look to their plain. We have annexed the plain. Therefore, we file an application. My application was detected in a summary manner. Lord, on holding now, your Lordship kindly come to my application under Order 2021 Rule 2. Lord, at page, your Lordship kindly come to at page 111. Lord, Memorandum of Understanding, 123, my Lord, page 123.
Yes.
Memorandum of Understanding. Now, my Lord, degree holder and judgment debtor name has been on the top of it. Now, my Lord, it has been adjusted, my Lord, clause 3. Clause 3, my Lord, it has been mentioned. Even, my Lord, from clause 1, your Lordship kindly read for your Lordship satisfaction. Adjustment, my Lord, in terms of the Memorandum of Understanding.
Yes, where is the impugn order?
Now, my Lord, your Lordship kindly look to the plain, copy of the plain, my Lord, for the time being. Lordship kindly look to that. They have filed a suit. Kindly come to the plain, my Lord. Only one paragraph, my Lord, I may place before your Lordship. Page 78, my Lord. Page 78. Page 78, my Lord.
They have again come off a suit.
Lord, he has come up as a suit. Lord, now, Lord, page 78, it says, Lord, that is section 14 to 17 to Lord 21 of the Contract Act, Lord, challenge it and their ground is, Lord, your Lordship kindly come to paragraph 2. That the alleged memorandum dated so and so is of no consequence as no property can be transferred on the basis of unregistered document, and the decree holder has already filed for declaring the said document is null and void. In the other suit, the issue relating to the said agreement will be decided by the suit court. Lord, this is the objection given against Order 21, Rule 2. Now, Lord, the suit which he has filed, Lord, that is that page. Lord, page 78, my Lord. Page 78, my Lord, suit is filed.
Yes.
Lord, paragraph 78, paragraph 2, my Lord, page 78, paragraph 2. That the defendant is the person who has forced the plaintiff to sign memorandum of understanding, and he is residing at the address mentioned in the call title. As the said notices, summons and process may be served upon him through the court of the above mentioned address. Lord, this is the case made out. Lord, when after 18, my Lord, the memorandum of understanding was executed, 2021, my Lord, suit was filed. That is why, my Lord, execution was not levied, not proceeded with. Lord, now your Lordship kindly come to a page. Lord, page 88. Page 88. A decree be passed cancelling, rescinding the memorandum of understanding entered between the plaintiff and the defendant. Decree declaring that the memorandum of understanding to be null and void, having executed by the plaintiff without free consent. Now,
Yes.
Lord, what is to be done? Decreed agreement dated on the basis of the said memorandum of understanding. Lord, therefore, according to the pleading, Lord, furnished by the decree holder, both in the plaint as well as in the objection against my application under Order 21, Rule 2, Lord, a voidable contract. Now, Lord, voidable contract, my Lord, will operate till it is declared to be void by the court. And what now your Lordship kindly come to the order impugned. Come to the order impugned. You are at page 165, my Lord. Learned counsel for the judgment data did not endorse the copy of the alleged endorsement of understanding to those who the came. On the other hand, the decree holder denied to such adjustment on the ground validity of the said move was questioned in another pending civil suit. Further, the case revealed the present execution, now Lord, present execution case pending in a ripened stage. Read for delivery of possession had already been issued. Though more is question was executed in the year 2021, judgment data proposed for adjustment on the basis of the document at the back end of the execution case that true after exhausting all possible means to prevent the execution case by way of filing application under section 47, etc. In my opinion, the petition for adjustment of the decree had come to the court at a very delayed stage only in order to stall the execution proceedings on the pretext of adjustment. Order 21 Rule 2 provides for adjustment of degree according to Sub-Rule 2(1), where any money payable under a decree of any kind is paid out of court or a decree of any kind is otherwise adjusted in whole or in part, satisfaction of the decree holder. Decree holder shall satisfy the payment adjustment to the court, whose duty is to execute the decree, and the court shall record the same accordingly. According to section 2A, no payment or adjustment shall be recorded at the instance of judgment data unless the payment is made in the manner provided in Rule 1. or the payment of payment or adjustment is proved by documentary evidence. The payment or adjustment is admitted by or on behalf of the degree holder in his reply in the notice. Reply in the notice. Finally, the sub-rule 3 says payment or adjustment which has not been certified or recorded the report says shall not be recognized by any court executing the degree. Thus, the provision of law makes it clear that the decree shall be adjusted based on a certificate as well as admission of such adjustment by the degree holder. But this is wrong, my lord, because it has to be proved by me. In the case of denial, documentary evidence I have given. Therefore, it has to be decided on trial. And practically, my lord, suit court, my lord, cannot decide this. Because unless certificate is given by an executing court, in either way on trial, Lord, that document cannot be acceptable even in a suit court.
No certificate, how can the certificate be issued without the consent of the parties?
No, the consent of the parties, if parties say that execution is admitted. Lord, my answer is execution is admitted. Now they are saying the case of under section 14 to 17 of the Contract Act. That is their case made out. Therefore, it is a case for a trial. We shall have to prove it. If on adjudication it is proved no such Lord fraud or coercion or undue influence is made, then in that case, court is entitled to adjudicate it because the document they are holding. It cannot be rejected, my lord, on a summary proceeding. Can it be rejected in a summary proceeding? If he disputes it, if he admits it, then and there he can. Your lordship is absolutely right. Then and there certificate is to be given. If the other side, my lord, if the decree holder disputes it, on the ground, dispute not on the ground of execution, not on the ground of fraud, coercion, undue influence, then what will happen?
Whatever may be, the decree holder has to come to the court with the so cause that I am consented with the adjustment.
Yes, now he is saying this. Now the decree holder is saying that fraud, undue influence, coercion,
Yes.
whether that is done or not, whether this is because execution is admitted, whether coercion, undue influence is a fact,
That is
which is denied by me.
the ambit of the execution court, sir.
Ambit of the execution court, right, my lord? Therefore, this cannot be decided in a summary proceeding.
He cannot allow
At
the,
least evidence is to be taken.
he cannot also allow the petition. You cannot
Lordship,
application. He
yes.
cannot allow the application under order 22 rule 2.
No, he can allow. He
How?
can allow the application or he can reject the application, provided the adjudication is to be made. According to me, freely they have executed. According to them, no, not freely executed. Then who will decide, my lord?
That's why the consensus has to be made before passing an order under order 21 rule 2.
Yes, consensus, my lord, has been made by execution of the agreement.
So by this document, it cannot be said. So
No, by the, yes, document in writing.
only the document before the executing court is the so cause. So cause is not there.
Lord, your lordship kindly come to the language B, 2AB. 2AB. Adjustment is proved by documentary evidence. Now, Lord, execution adjustment is proved by documentary evidence. Lord, I am stressing this language of the legislature.
That is yet to be proved.
Yet to be proved.
Yes.
Yes, yet to be proved that their allegations are denied by us. We say, but execution is admitted.
What you want here?
But execution is admitted.
So what your prayer here?
My prayer is that maybe set aside. He said how, your lordship kindly, the conclusion paragraph. The present case, the decree holder in this so-called had denied to any adjustment of the decree on the basis of amount in question. In simplest, decree holder neither certified nor admitted the adjustment as paid for by the judgment debtor. But there is no question of passing any order as to the adjustment of the or adjustment of the degree. Because this is the misinterpretation of the section. According to me, my lord, according to my client, he executed it with conscious application of mine. He agreed, voluntarily agreed. Then he changed his mind. Then filed a suit. Now, the execution of the document is admitted. No dispute. But his case is that it is hit by a doctrine of fraud, undue influence, and coercion. Lord, who will prove? I will prove, or they will prove. By leading evidence, B, Lordship kindly adjustment is proved by documentary. How it can be proved, my lord, without taking evidence? It cannot be decided in a summary manner. This is the question of law, my lord. This question of law is required to be decided by your lordship.
Very well.
And accordingly, my lord, order 21 will do it. But if in the event, my lord, it is adjudicated by the executing court that the allegation raised by the degree holder is false, not correct, but execution is admitted. Contents are proved by the judgment debtor. In the event I prove the content event, and execution is admitted. Therefore, I need not prove the execution at the trial. Lord, this is a crucial question, Lord, which is whether it can be decided, Lord, summarily, or it can be decided by trial. At
No.
best, my lord, your lordship can direct within a period of 15 days, this can be concluded
You
by
just
taking evidence.
hear it. Executing court had no scope to go into the merit of the understanding whether it was taken under the influence of coercion, undue influence, or otherwise. Executing court has no opportunity to visit this matter.
Therefore, executing court, according to your lordship, will not reject it, subject to the decision in the civil court.
No, the order 21 rule 2 is very specific. There must have some consensus. When there is no consensus, the petition has to be rejected. That is the simple question. He can summarily
Lord,
do the same.
Lord, with regard to that part, my lord, I am drawing your lordship kind attention. The adjustment of the degree, if any made or not, by any document. Answer is yes. By any document, adjustment of the degree is made. Now,
No.
second,
Is not valid at the instance of the decree holder.
he says that there is a fraud, undue influence, coercion.
Yes.
Now, my lord, executing court is required to determine that question. Like, my lord, order 21, rule 97, 101. Executing court has a right.
No. In the 101 is the scope is otherwise.
101, my lord, in the case of a independent title to the property.
No. Yes, it is in respect to the title of the property. This is not
Giving an independent title to the property by a third party.
very well hard.
Even executing court under section 47 can decide that.
Hard. Please take down. Instant civil revision has been preferred against the order. Dated 11th of October 2023, passed by learned Civil Judge Junior Division First Court Blair in other execution case number 5 of 2019. Stop. Heard the learned advocate. Peruse the impugned judgment, impugned order. It appears that the learned Civil Judge Junior Division Court Blair has rejected the application filed by the judgment debtor under order, judgment debtor under order 21 rule 2 CPC. Stop. It appears that the initially a decree of partition was initially a preliminary decree of partition was passed was made between the was passed by the learned jurisdictional court, and for the adjustment of decree, one MOU, MOU, MOU was executed between the parties, between the decree holder and judgment debtor. Stop. Subsequently, the judgment debtor filed an application under order 21 rule 2 CPC for getting a certificate from the court regarding the adjustment of the decree in question. The show cause was issued upon the decree holder, wherein the decree holder is of opinion that the memorandum of understanding within bracket MOU was executed under pressure of the judgment debtor. Of the judgment debtor, and he has filed an other suit being number 53 of 2021 before the civil court, challenging the said memorandum of understanding. After observing the show cause of the decree holder, the learned executing court had dismissed the petition of 21 rule 2 CPC. Rule 2 CPC. Learned advocate for the petitioner submits that the learned court below cannot, learned executing court cannot decide, learned executive court cannot decide the matter in a preliminary way. Stop. The execution of the document was well proved. Stop. Whether the document was, whether the execution was made under the influence of coercion or undue influence, coercion or undue influence has to be decided in the suit itself. Thus, the executing court was not correct in dismissing the application in summary way. Full stop. Had the learned advocate peruse the memorandum of understanding, also peruse the provisions under order 21 rule 2 CPC.
Lord, only one indulgence, your lordship gave leave to. Allow me, Lord, no payment, no adjustment shall be recorded at the instance of a judgment debtor, unless the adjustment is proved by documentary evidence. So
Yeah.
how can I prove it without evidence? How can I prove it without evidence by denying the allegations made by the degree? On the other hand, degree holder, Lord, this argument I am also making.
Okay. understanding
Also paying the provision and all, we do the six.
rule 2 CPs. Considering the merits underlying in the instant civil division, the instant civil division is admitted. Stop. Principles therein.
Underline the instant civil division.
The instant civil, the civil division is admitted. Stop. Have you prayed for any stay?
Yes, my lord. I have prayed for a stay also.
There shall be a stay of further proceeding of execution case being other execution case number 5 of 2019 till since 8 weeks till cut off, since 8 weeks from this date. Stop. The petitioner to serve upon the opposite parties. Let the matter appear. No. Petitioner at liberty to mention. Is at liberty to mention? Yes, you
But I
are.
am deeply obliged. my lord.
Item is- Yeah, না? ঠিক আছে। না, আগে কোনটা আছে? সবটা আছে। ঠিক আছে। হচ্ছে এটা কি আছে? কি আছে দেখেন? Yes, call the list.
Item number 7, WPA 970 2023.
Lord, I'm appearing for
My
the
lord, in this
respondent.
matter,
Lord.
I'm appealing for the petitioner, my lord. A prayer for water connection, my lord. I had made my application in annexure P3, page number 2, my lord. But the respondent authorities are not providing me the same. I'm 75 years old, senior citizen. I'm just requiring the basic necessity of water connection.
Yes,
Lord, it is Choldar. I just take instruction, Lord, but it is served to me.
what instruction?
Whether it has been provided or not, I don't know.
Not it, my lord. That is the reason the
And my lord,
it has been.
Where is the application?
Page number
12.
12, my lord, annexure P3.
Yes.
It's an online application.
But sometimes it's happened.
It's
my lord.
online
and
application.
everything We had given.
So just a day's accommodation, I will take instruction. My lord, the difficulty is they have a right to grant the water tap connection. But sometimes where there is no pipelines have been laid.
Whatever may be, you take instruction. You cannot argue on that point without instruction.
Yes.
Okay, you can come on Monday. Monday. Not today.
Yes.
Next.
Item number 8, WPA 970 2023.
My lord, in this matter, I am appealing for the writ petitioner, my lord. Here in this case, my lord, we are for the petitioners, we had filed a civil suit before the learned court below. We obtained preliminary decree, commissioner got appointed. Partition report came, final decree has also been drawn. We went before the deputy commissioner for subdivision of our landed property. Notices were issued, but till date, the
What
assistant
happened?
commissioner is not.
My lordship, I am, let it be considered, my lordship. With certain time period may be given, we will consider it. In accordance with law, it can be disposed.
My lord, my first application at page number 42, annexure P5.
Yes.
P5, my lord, and subsequently reminder at page number 46, my lord, annexure P7. On 8 August, but till date. They have not disposed.
Please take down. You take decision within December.
Yes, my lordship.
the petitioner has made a prayer before the Deputy Commissioner, South Andaman District Port Blair on 17th of January 2023 to subdivided a landed property on the basis of a final decree passed by a court dated 5/12/2022. The respondent authority has not acted according to the prayer of the petitioner. Hence, the petitioner is before this writ court. Stop. The respondent authority is represented are the learned advocate for the respondent authority. Considering the submissions of the parties, the instant writ petition is disposed of with a direction that the respondent authority shall dispose of the petition filed by the present petitioner on 17th of January 2023 within December 2023 after awarding an reasonable opportunity of being heard to the petitioner. A reasonable opportunity of being heard to the petitioner. Stop. Next para, the concerned authority shall arrive at a just decision, just decision according to the law and the prevalent regulation in the Andaman and Nicobar Islands. Stop. The authority must inform the reasoned decision to the petitioner within a fortnight after such decision. Disposed of.
My lordship, since AO is not filed, that may be deemed to be denied and disputed.
Okay, okay. The as the affidavit are not exchanged, thus the allegation made in the petition shall deemed to have been not admitted. Stop. The authority shall take independent decision in the matter without being influenced by any observation made by this court. Yes.
My lordship.
ঠিক আছে
Item number 9. CO4 of 2023.
Lordship, in this matter, I am for the revisionist. This revision application is filed against the order of the learned. May I start, Lordship? This execution case is filed against the order passed by the learned civil judge senior division Mayabandar in a execution case by which one part of the decree was allowed and failed to execute the other part of the decree. The background of the case is, Lordship, the plaintiff, the petitioner herein has.
Okay, just wait. So we can start at 3:30 today. Mr. Ilango is there, one argument has to be concluded today. That is to come on 3:30, take a lunch at least. Okay, come on 3:30. Okay, no issue.
Other matter may kindly.
No, I'll take all the matters. Why other?
I got one urgent matter, next matter, 10, item number.
I'm coming on 3:30.
3:30.
Yes, all the matter. Let's see how can we done.
Item number 9. DO 4 of 2023.
Lordship, in this matter, I am for the revisionist. This revision application has been filed challenging the order filed by the Learned Civil Judge Senior Division North and Middle Andaman in an execution case in which the Learned Court has allowed execution of one part of the degree and failed to allow the second part of the degree. The background of the case is at the beginning, the petitioner herein has filed a other suit under section 6 of the specific relief act. On contest, the suit was decreed in favor of the petitioner herein, and it was directed that an amount of rupees 10,000 has to be paid as compensation, and the khas position has to be given to the petitioner herein. During the statutory period, the khas position could not be given. So the petitioner herein has filed the execution case. In the execution case, the other side counsel, they also appeared. And the execution court has issued a attachment decree. And when the bailiff has gone to get the property attached, during that time, the defendant herein, they have requested that they are ready to give the position, but they don't know the extent of the suit property. So the same report was conveyed to the execution court. Execution court on this report has directed the Tehsildar North and Middle Andaman to, with the assistance of the surveyor, to provide the extent of the suit property, and the day was fixed for the survey. During that day, Lordship, the surveyor, while demarcating the land, he said that the survey number 130, which is a suit property, in their record it shows it is a revenue land, so they cannot demarcate the land. And the same report was conveyed to the executing court. On that basis, the executing court has passed an order that as per the report of the bailiff, the one part, since it could not be surveyed, so it could not be decreed in favor. The khas position cannot be given to the petitioner. Now, Lordship, against which I have filed this revision application. Lordship, I want to show 2-3 things. The Lordship is well aware that in section 6 of the Specific Relief Act, possession is a material. Title is not at all material. Since I have enclosed the original certified copy, I have not paginated it, Lordship. Annexure P1, which is next to the affidavit, Annexure P1, I want to show page number 456. Inner page 456, Lordship. More relevant will be page number 6. Page number 6, paragraph 5, Lordship.
Annexure.
Annexure P1. Inner page number 6. P1 is the order passed by the lower court in the section 6, Lordship. Inner page number 6.
Yes.
Paragraph, Lordship, 6. It was argued from the side of the defendants. May I read, Lordship? It was argued from the side of the defendant that the suit land is a government land and no declaration can be claimed in respect of the same. But again, the suit is based upon de facto possession and not de jure possession. And in these cases, the court are not to see the legality of the possession, but only the possession. It matters little whether Ismail had any right to sell the suit. So this is the observation of the lower court, because this point was already raised that this is a government land in the lower court, and in the section 6 proceeding, the court has very much made it clear that in these cases the possession is important, and possession the petitioner has proved before the Honorable Court. Lordship,
So the suit was filed for restoration of
position and for the compensation.
and for compensation.
Compensation. Lordship, in P2, the most important P2 also, because the assailed order is here. P2 or last page, Lordship, order number 42. This order has to be set aside, Lordship. I have prayed for the setting aside this order. P2, last page, Lordship, order number 42. Now, this is today it is fixed for payment of the decretal amount of rupees 10,000 by the judgment debtor, The decree holder and the judgment debtor are present along with their learned advocate and they file hajra. The judgment debtor file a petition for making payment of the decretal amount of 10,000. Such payment is received by the decree holder through his learned advocate, and the endorsement of receipt of the same is made by the learned advocate for the decree holder in petition filed by the judgment debtor. The learned advocate of the decree holder issue receipt payment of decretal amount of 10,000 for judgment debtor in view of the fact that the payment of decretal amount of rupees 10,000 has been paid by the judgment debtor. Today in court, the execution case stand disposed of on full satisfaction. Full satisfaction, it's not there, Lordship. There is no, only half of the satisfaction has been.
Okay, I understand.
Yeah.
So you serve?
Lordship, I have served twice, one through the registry, and on the last circuit, on the direction of the learned judge, I have served through the police station. So twice I have served, but nobody has appeared from the side of the respondent.
It is a contest.
It is, yes.
So why not respondents are appearing?
The service is already there on the record, Lordship, twice.
Then I have to appoint one person from the district legal service authority to represent. Otherwise,
Lordship, they have not come forward to get this.
how?
They should at least come forward.
Ex parte decree cannot, ex parte order cannot.
Yeah, I
I
do
know,
understand,
you know.
Lordship.
You know. So whole matter cannot be concluded today.
Or Lordship, one person may be appointed as your Lordship
Yes.
feels, yes.
Okay, please take down. The instant civil revision is appear for hearing before this court. It appears that it appears for hearing before this court. No, one order was there to Mrs. A. Jinno to serve through.
She has already served, Lordship. She has served. She has already.
Okay. None appears on behalf of the respondent. Stop. It appears from the record that the service was effected upon the respondent through court as well as through local police station.
Local police station.
Considering the aspect, the matter cannot be heard ex parte. Stop, comma, the state legal service authority. State legal service authority is requested to appoint one learned advocate to represent the respondent before this court on state exchequer. Stop. Let the order be communicated to the state legal service authority through to the state legal service authority through registry. Let the matter appear.
Chief Judicial
On the next-
Magistrate is the secretary.
That is the district legal service authority,
Not district.
but it is the state legal, high court is.
State legal.
To the registry. Let the matter appear on the next appellate circuit.
I'm grateful.
Let one appear, otherwise
Lordship.
it cannot be heard.
Lordship, I'm
I
grateful.
understand your merit is there, but it cannot be disposed of ex parte. Next,
Item number 10. 44 of
I am sorry,
The respondent.
eviction proceeding was initiated by the state office. Ultimately, eviction order was passed. I filed the appeal before the Leonard District Judge. Page 98, madam. I will refer only the order sheets. Page 98 is the order sheets of the Leonard District Judge.
order of estate officer,
No, my lord,
estate appeal.
Yes.
State appeal before the learned district judge.
Yes, yes, yes.
Very well.
Page 98, my lord. It was filed on 11/1/23. My lord, same day I moved a stay application, stay was granted, page 100.
Yes.
Page 100, accordingly, let there be a stay of impugned order. Thereafter, my lord, lordship kindly come to order number 5. Order number 4, my lord. Page 102.
Okay.
I filed 151 application, madam. 151 application, the said application is appearing at page number 78.
For why? For why? Why you filed that?
I
151?
filed the 151 application to operate my unit, to operate the unit. 151. It was fixed on 3/7. Kindly come to last order. Page 105. I completed my hearing on 15/6/23. 105.
Yes.
105, my lord. Hearing was taken place for 151. The learned district judge dismissed the entire appeal. No argument was advanced for hearing of the appeal. Kindly see this order, my lord, 105. I am reading. Today is fixed for further hearing of application under section 151 of the CPC. Parties have been taken their respective steps. Learned counsel appearing on behalf of the parties are present. Learned counsel appearing for the respondent files written objection against the application 151 CPC. In the appeal consideration of section 9 of the public premises, eviction of unauthorized occupants act, so and so. Copy served. Case record is taken up for hearing of 151 application. Date considered both the parties interim order extended so and so date 3/7/23. On 3/7, my lord, appeal was dismissed. Kindly see impugned order, page 108. July 3rd, same date. I did not argue anything on appeal. The interesting part is that, my lord, there is an arbitration clause. Entire appeal was dismissed, my lord. Page 49 is the arbitration clause. So this matter should go back to the learned district judge, my lord, to decide my application first 151, thereafter decide the appeal. Page number 49, serial number 9 may be seen, my lord.
No.
Arbitration clauses.
No, you have, please gone through the certified copy you have annexed.
My lord.
The appeal coming on hearing, coming on this day, having heard on 5/15/6/2023
No, my lord.
in presence of Muhammad Blair and Miss Bobita. That is the last document you have annexed.
In the order sheet, it is not there, my lord. Order sheet, it is not there. And moreover, arbitration clause is there, my lord.
No, I am not going to the merit in this matter. I am just.
151
Arbitration clause is not relevant at all because it's just public premises.
That
Public
is the
premises.
merit. I am not going to the merit in now in this
My
matter.
lord.
The arbitration.
13/7, my lord. 3/7, my lord. 151 application was filed. Hearing concluded.
No, that hearing concluded on 15/6.
No, order sheet say some other thing, my lord. Order sheet I enclosed, my lord, entire order sheet.
15/6 was fixed for what?
15/6 is fixed for hearing passing order in respect of 151 application.
Okay.
Order is to be passed on the application filed by 151. I did not advance any argument on merits of the case. This should go to the learned district judge, my lord, to decide afresh.
Only one hearing you want.
hearing of 151 application, thereafter the appeal can be heard.
No, I can, so what is your submission, Mr. Chiku?
There is 151 application. If my learned
Yes,
senior
it is
can
there.
point out which page it is there, but
It is
I'm
there,
not
it is
able
there.
to find it.
He is pointing out page number 105.
No,
78,
that I've seen, my lords, but
Page
I'm only
78,
submitting.
page 78 is the 151 application.
Whereas all the grounds are same grounds are taken as in the appeal, my lords. There is no difference, my lords. But see page 84 onwards. This is they are challenging the order of the estate officer, page 84.
151 application is filed with the prior that an order restraining the respondents from preventing the appellant.
No, that is, no, that's, I appreciate, my lords, but my lords, the grounds and the arguments are the same. Page 84 may be seen.
Maybe.
Why should?
However, the date was fixed for hearing of the application, for hearing of the application, not the.
No,
entire-
my lords, I appreciate that, but my lords, the point is that if the same arguments are taken, then my lords, why will it?
No, issue is there that the London district judge has heard the petition.
By mistake, my
application. However, that can be heard once. One opportunity has.
My lord. But my lords may say that, opinion.
Along with the appeal.
Appeal.
Along with the appeal, 151 will be disposed of along with the appeal.
Maybe disposed of with the.
Yes.
This 151 application may be fixed on Wednesday. I will do it. Thereafter, after 3-4 days.
No, my lord.
Why-
It is,
why no?
he has rejected, my lords.
I am ultimate sufferer, my lord.
Yes, I know you are the sufferer.
I am ultimate
So
sufferer.
why you want to delay the matter?
No, we should not delay. I obtained some document under the RT Act that has to be filed before the.
In that case, my lords, this judgment should be treated as rejection of his 151.
No.
Let the appeal be heard, then. Both things cannot be done. He wants to delay the proceedings.
No, proceed not delaying. Lordship can fix a date. 151 application, Wednesday.
151 is already rejected.
Why?
No,
Why?
not
Why 151?
No,
Appeal.
why you are not ready to argue the matter with the 151?
Why? Because I am not in possession of the property. The other cases, similarly placed cases, the honorable single judge passed order giving.
In this very case, High Court has rejected this relief. How can this submission be?
No, I am not going to the merit of the anything of the, you just want to hear,
Yes.
want an opportunity of being heard, that can
My
be
lord,
given.
my lord. Yes, my lord.
That can be given. I am specific direction is giving. On that way, I will set aside the order also itself.
My lord.
Okay. Please take down.
My lord may only say that now observation on merit because my lord.
Yes, no objection.
My lord.
Nothing on me.
Please take down.
2023 matter, my lord. I am not delayed.
The instant criminal revision has been, civil revision has been preferred against the, order dated 7/3/2023, passed by the London district judge. Being an appellate forum under section 9 of the Public Premises within bracket Eviction of Unauthorized Occupants Act 1981. Stop. No, 1971, sorry. Stop. It is the sole contention of the learned advocate for the petitioner that he preferred the appeal before the learned district judge against the order of estate officer for eviction. Stop. During the pendency of the appeal, one application under section 151 of CPC was preferred. 151 of CPC was preferred by the appellant. Stop. The date, that is 5/6/2023, was fixed for hearing of that application. 15th June. 15th June 2023. No, 15th June. 15th June 2023 was fixed for hearing of that application. Stop. The learned district judge has heard the application from both sides and fixed the date for passing order on 3rd of July 2023. On perusing the order dated 3rd July 2023, it appears that the learned district judge has dismissed the estate appeal on contest. Stop. Learned advocate for the appellant submits that he never argued before the learned district judge regarding the merits of the appeal. Regarding the merits of the appeal, so an opportunity be given to the appellant to argue his matter by setting aside the impugned judgment. Or the learned advocate peruse the impugned order along with the order passed by the learned district judge in 15/6/2023. 6/2023. It is true that the learned district judge actually not heard the appeal from the appellant, from not heard the merits of the appeal from the appellant, of the appeal from the appellant, from the appellant. Considering the same, I observe that the appellant should have been given an opportunity of being heard regarding his merits of the appeal. Given an opportunity of being heard regarding his merits of appeal. Stop. According to the instant criminal next instant civil division is disposed of with a direction that the learned district judge shall hear out the the appeal along with the application under section 151 CPC filed by the appellant and passed a region order after stop. Consequently, the impugned judgment and order passed by the learned district judge is set aside. Stop. I make it clear next. I make it clear that I have not observed the merit of this instant appeal, and if any observation is made regarding the merits of the appeal, the district merits of the appeal, the district judge should not have influenced on the above observation. Stop. The district judge shall dispose of the appeal on the merits itself. The merits itself after awarding an reasonable opportunity of being heard to both the parties. Let the matter be disposed of within November 2020.
During pendency of this original application, this CO method, I applied under the rules for hearing space for understanding. I want to bring on record before the Senate court below.
You make necessary application before the district judge. Why is it here? I don't have don't have the opportunity to visit the merit or anything. So you can make an application before the. Yes.
I was only record when after recording his submission that we have objected.
Yes.
Advocate for administration appeal the
Yes. Learned advocate appearing on behalf of the administration submits that the impugned judgment has noted that the matter has been heard from the both side on 15/6/2023. On 15/6/2023, and thereupon the judgment was passed.
Play.
Item number 11. Here is the 5 of 2022.
Rest matter left. Rest matter released.
This matter release.
A2 चला.
Yes.
My lord, yesterday there was one question put by this honorable court that whether section 42
Has
will be
any
application or not in a
the
public place.
public.
Now, my lord, may kindly come to page number 39, my lord. Page number 39, my lord.
Yes.
That's a jetty. Jetty is a restricted area, and there's a gate that has been marked as B, jetty gate. And thereafter, inside the jetty, there's a place called A, which is the spot from where the alleged seizure was effected.
Okay.
So there, inside the jetty, my lord knows that the particular place can never be treated as a public place, because it is governed by port rules and port acts. And there is a restricted movement of entry. General public cannot go, because that is not the place where every vessel, means every vehicles or every persons can go. One has to enter into the particular jetty either after obtaining the necessary passenger ticket, or they will have to show the bill of lading. So these are the things that is to be seen. I can understand if the said thing was done in the midst of the roads, in the park, even in the theaters, but not inside the jetty, because jetty is a restricted area. Now, my lord, I have said that I would be showing the judgments. My lord, first was with respect to the one by one. I'll place, my lord. My lord, what I said earlier, this is with regard to the application of section 52A.
Yes.
That is, the officer who has effected the seizure will have to prepare an inventory, and that inventory has to be placed before the concerned magistrate. Magistrate will have to then check whether it is in consonance to the inventory or not.
Yes.
And thereafter he will have to issue a certificate in terms of section 52A. Now, but when we had gone through the evidence of the IO, who has only said, who has only got it exhibited, the evidence of IO is at page number 15, my lord. Paragraph 4 may kindly be seen, my lord. Page number 15. My lord, got it. I examined the available witnesses, recorded the statements. I arranged for obtaining sampling certificate from the learned magistrate, and I collected the certificate. This is the certificate marked as Exhibit 9, my lord. He has never stated that after the seizure was effected, I had prepared the inventory. The said inventory was forwarded, Now, my lord, may kindly come to exhibit 9, my lord. What are the discrepancies? That also I will show, my lord. My lord, may kindly come to page number 40, which was exhibited through the IO, stating to be, because mere exhibiting a document will not do. My lord knows that. Exhibit 40, my lord. My lord, the first column may kindly be seen. One number of sealed plastic bag containing illicit ganja of 5.3 kgs, my lord. Now, my lord, may kindly come to the third paragraph. Now, here he says that 5.21, then 5 kg approximately. My lord, got it? This discrepancies, this is not for the first time. Now, my lord, may kindly come to page number 42.
No, what is the item, column number 2?
My lord,
Number
first
one.
column is
Number 1.
narcotic drugs, psychotropic controlled substance and conveyance. Now here at the last portion, it has been mentioned that one number sealed plastic. I'm reading from column number 2, my lord. First column is serial number 1. Okay, column number 2. Plastic carry bag containing illicit ganja quantity 5.3 kgs. That is
Yes.
5 kg 300 grams. Now, my lord, may kindly come to column number 4.
Original
Quantity. Now here it is mentioned 5.21, then 5 kg approximately.
No, whether 5.215 kg?
No. 5.21 kgs. Thereafter 5 kg approximately. Why I am saying so is that kindly come to page number 42. That discrepancies will be clear.
No,
That is-
why come to column number 6?
Column number 6, my lord.
Quantity found present after drawing.
After drawing the sample, 5.165 kgs approximately.
Yes. So 20 grams of 2 packets has
Been taken.
Has been taken 20 plus 20, 40 gram. Yes, it is in the column number 4, it would be 215.
215, my lord.
Yes.
5.215. 1 second, my lord. 215. 1005. 900. 5 point. My lord, it will be correct. 5.215.
Yes.
Because I was under the impression, kindly come to paragraph 42, my lord. Page number 42.
Yes.
Here also it was written 10.0, then 5 kg approximate.
Yes, yes.
It should be 10.005 kg
Yes, yes.
approximately.
That is the total marks.
Now, my lord, here I would say that there is a sheer non-compliance of section 52A.
52.
Yes. For which I am placing the judgment, my lord. This has been passed by our Honorable High Court. (2000) Volume 1 CHN 803. My lord, may kindly come to Tej Bahadur Singh versus NCB. My lord, may kindly come to page number 4.
Paragraph.
Paragraph 10, my lord.
Paragraph 10. Yes.
Mr. Bose, learned advocate for the appellant, submits that in the present case, it appears that evidence on record that the samples were taken out and sent for chemical examination without complying the provisions of section 52A of NDPS Act. Bose drawn our attention to the provisions of section 52A subsection 2 of the Act, where any narcotic drug, psychotropic substance has been seized and forwarded to the officer in charge of the nearest police station. The police officer empowered under section 53, the officer referred in subsection 1 shall prepare an inventory of such narcotic drugs or psychotropic substance containing such details relating to their description, quality, mode of packing, marks, numbers, so and so. Referred to in subsection 1 may consider relevant to the identity of the drugs, and second, my lord, and make an application to the magistrate for this purpose, certifying the correctness of the inventory prepared.
Yes.
So these things were not done. Now, my lord, may kindly come to paragraph 16. And 16, we should keep in mind that one of the objects sought to be achieved by the legislature for introducing section 52A in the Principal Act of 1985 is to prevent substitution of the article. Article after seizure can be substituted when it is in the custody of the officer or the department which seizes and comes into possession of the articles after seizures. If these procedures are not followed, the possibility of substitution of the articles cannot be ruled out. In the present case, in view of the facts and circumstances stated above, it can be reasonably said that the articles which were seized from the possession of the appellants were not sent for chemical analysis by PW1 and were affected by substitution. Otherwise, there could not have been so many discrepancies in the prosecution evidence with regard to the identity of the articles. But thereafter, in view of the discussions made herein above, we are of the view that the provisions of section 52A of the NDPS Act is mandatory provision in as much as the provision was inserted in the Act for a definite purpose to prevent substitution of the articles by concerned officer of the department. We are of the opinion that non-compliance of section 52A makes the entire search and seizure vitiated. The prosecution has failed to prove the case how the sample packets which were admittedly in the custody of the NCB officers till 13/7/1995, when the same was produced before the court, permission was granted by the court for sending the same for the chemical analysis, could be received by the office on so and so so and so. My lord, the second judgment. Lord, 2014 Supreme Court. This is the famous judgment, my lord, Permanence judgment, my lord. May know the applicability of section 50.
Yes.
If only the here, my lord, may kindly see, accused bag was searched and opium was recovered. His personal search was also carried out. So the provisions of section 50 is applicable. Now, how we will come to understand whether the personal search was conducted or not, my lord, may kindly come to the evidence of PW1, my lord. Paragraph 3, Exhibit 2, last, just above that 3 line, my lord. Page number 2, my lord, may kindly see. Page number 2, evidence of PW1.
Yes.
My lord, point number 1, 2, 3. Last 3 lines, my lord. I asked him for personal search, my lord. This is the person who has served him the notice. Now, my lord, may kindly come to notice under section 50, my lord. Page number 29 may kindly be seen, my lord.
Yes.
That may I just read it, my lord? Where there is a reason to believe that you are in possession of so and so so and so. Therefore, we would like to conduct your personal as well as your belonging search. If it was only for the belonging search, then the applicability of section 50 will not be there because it was for the personal and the belonging search. So the applicability will be there. And here, my lord sees. So far as the option of being searched before the magistrate is concerned, it was not given. Option of being searched before the nearest gazetted officer, that was also not given. The third option was given to be searched before the officer who was accompanying them. There is no provision of giving any third option. AR 2014 Supreme Court 1384. My lord, may kindly come to paragraph 11, my lord.
Yes.
Of this particular judgment. Paragraph 12. If merely a bag carried by the person is searched without there being any search of his person, section 50 of NDPS will have no application. But if the bag carried by him is searched and his personal search is also searched, section 50 of the NDPS will have application. In this case, respondent number 1, Permanent's bag was searched. From the bag, opium was recovered. His personal search was also carried out. Personal search of the respondent number so and so was also carried out. Therefore, in light of the judgments of this court mentioned in this proceeding, section 50 of the NDPS Act will have application, my lord. Now, my lord, may kindly come to paragraph 15, my lord. May I read paragraph 15?
Yes.
Sir? We also noticed that PW10, SI Qureshi, informed the respondents that they could be searched before the nearest magistrate or nearest gazetted officer, or before PW5, JS Negi, that is superintendent. Here in our case, it was one Mr. Hukum Ram, who was the DYSP. Now, my lord, it is the prosecution case that the respondent informed the officers that they would like to be searched before JS Negi by PW10. In our opinion, there is again a breach of section 50 subsection 1 of NDPS Act. The idea behind making an accused to a nearest magistrate or nearest gazetted officer, if he so requires, is to give him a chance of being searched in the presence of an independent officer. Therefore, it was improper for SI Qureshi to tell the respondents that there is the third alternative available and that they could be searched in before JS Negi, that is superintendent, who was a part of the raiding team.
Part of the raiding party.
Part of the raiding party. JS Negi cannot be called as an independent officer. We are not expressing any opinion on the question whether if the respondent had voluntarily expressed that they want to be searched before JS Negi, the search would have been vitiated or not, but PW10 could not have given a third option to the respondent when section 50 subsection 1 of the NDPS Act does not provide for it, and when such option would frustrate the provision of section 50 subsection 1 of the NDPS Act. On this ground also, in our opinion, the search conducted by so and so is vitiated. We have therefore no hesitation in concluding that breach of section 51 of 50 subsection 1 of NDPS Act. My lord, may kindly again come to page number 29, my lord.
Yes.
Here, my lord. He himself is telling a gazetted officer is also present with us. If required, we will search before him. That means the third option is being given, but the actual thing that is nearest to gazetted officer and nearest magistrate has not been given. This option has not been given. Now, my lord, again, non-compliance of section 55, my lord. My lord, paragraph. My lord, I'm just reading for the sake of convenience what section 55 says.
Yes.
My lord, police to take charge of the article seized and delivered. An officer in charge of the police station, that means the SHO, shall take the charge of and keep in safe custody pending the orders of magistrate all the articles seized under this act within the local area of that particular police station, and which may be delivered to him, and shall allow any officer who accompanies such articles to the police station or who may be deputed for the purpose to affix his seal to such articles or to take samples of land from them, and all samples so taken shall be sealed with the seal of officer in charge of the police station. My lord, the judgment what I am referring to may kindly come to para 16 of this particular judgment, my lord. 2004, volume 2. No, it's ALL MR CRI 1922. My lord, may kindly come to paragraph 16, my lord. Bombay High Court. May I just read it, my lord?
Yes.
Apart from non-compliance of mandatory provisions of section 42 of the NDPS Act, in the instant case, what we have noticed that there is no compliance of mandatory provision of section 55 of the Act, which provides further safeguard requiring it mandatory to police officer to affix his seal after the property has been received. Section 55 clearly goes to show that all samples taken from the seized materials under this Act have necessary to be sealed with the seal of the officer of the police station. This is a mandate of law, and the words used are shall, leaving no discretion in the hands of the concerned. Considering the severe nature of the punishment provided in the Act, every provision of this Act has to be strictly construed, and any non-compliance will automatically render the prosecution a suspect. In a case beforehand, evidence of so and so, superintendent of police, it is only evidence. It is the only evidence that is on which prosecution was rest its claim for conviction, lacking in substance relating to compliance of provision under section 55 of Narcotics NDPS Act. In the first place, none of the witnesses have stated even a word about having made compliance as required under section 55 of the NDPS Act. Here also, none of the witnesses have said that they have complied with the provision of section 55. That means the officer who has seized it, after seizing it, he will have to hand it over to the SHO concerned, which he has never stated. Rather, he has even not stated as to where these articles were kept.
Yes.
Last line, 17. So having regard to the legal provisions contained in 42(1)(2) and section 55 of the NDPS Act, it is crystal clear in the instant case there has been frugal violation of the mandatory provision, which resulted in great prejudice to the accused, and therefore the search as well as the trial is vitiated.
Yes.
Now, this is another judgment, 2007. This again is a celebrated judgment, my lord. Dilip versus State of MP, Supreme Court cases, my lord. State of MP, 2007, Volume 1, SCC 450. Decided by their lordships SB Sinha and their lordships Markande Kajju. Now, requirements of section 57, my lord. Because immediately after the seizure, a report needs to be sent with regard to the seized articles, my lord, to his immediate superior officer within 72 hours, my lord. Section 57, my lord.
Yes.
That thing has not been done. Even the complainant nor the IO has said that any such compliance was done, and no such documents was also exhibited. Section 57, my lord. तो बस खत्म कर देगा ये। My lord, may kindly come to page number 455, para 6. The provisions of section 52 and 57, which deal with the steps to be taken by the officer after making arrest or seizure under section 41 to 44 are by themselves not mandatory. If there is non-compliance or if there are lapses like delay, etc., then the same has to be examined to see whether any prejudice has been caused to the accused, and such failure will have a bearing on the appreciation of evidence regarding arrest and seizure as well as on the merits of this case. Now, my lord, here there is no delay. The thing is that there was no compliance at all. It was not partially complied. It was not at all complied. ये दे दो. But I think I had given it already. Well, that I think I have given it. The earlier judgment was with regard to the option of giving third option. I'll just read it, my lord. The previous one, my lord, 2016 CRLJ 1021.
Regarding the option.
Regarding the option,
to be
option.
served before the gazetted officer
Yes,
and
yes, yes.
magistrate. Any third option given to the
Will
client at trial.
vitiate the.
You have already given.
Yes,
it.
my lord. My lord, then it's Supreme Court of India, my lord. It's State of Rajasthan versus Gurmail Singh, my lord. My lord, this is also very important judgment, my lord. NDPS Act, link evidence. Seized article kept in Malkhana for 15 days. Malkhana register not produced. Sample of seal not sent to laboratory for the purpose of comparing the seal appearing in the sample bottles. Therefore, there is no evidence to prove satisfactory that the seals were found were intact. The same seals were put in the sample bottle immediately after the seizure of the contraband. Acquittal upheld. My lord, here again in our case, my lord, may kindly come to paragraph 3, my lord. This is with regard to non-production of the Malkhana register, non-examination of the Malkhana in charge, the link evidence with regard to the place where the articles were kept.
No, in this case, there is no such
No,
thing.
nothing is there.
Where it was.
Yes,
kept.
where it was kept, how it was taken, who has taken it to the concerned officer, then where it was again brought back from the magistrate concerned, where it was kept, then on which date it was taken, who has taken, nothing is there, my lord. वो तो देखिए पढ़ना नहीं देते. This judgment is of our Mother High Court, my lord, Justice Indira Banerjee and Justice Kamalji Talawaliya, my lord. Panchan Karmakar versus State. My lord, may kindly come to page number 1, 2, 3, 4, 5, 6, 7, my lord. Page number 7. Last paragraph. The above infirmities further lends force to the argument advanced by the learned counsel for the has not proved the link evidence. Same, my lord.
Yes,
Link evidence.
this is also linked.
Link evidence, my lord, because they are after the search samples were drawn at the spot on so. So furthermore, it is the case of the prosecution that so arrived at the police station and handed over the case property and sample to the SHO, and he has deposited the case property samples in the judicial Malkhana on 13/9/2022. From 9 to 13, where the case property and samples remain, nothing has been explained. Whether they were deposited in the police Malkhana or personally retained by the SHO, we have to group in the dark. Nowhere it has been stated by the SHO that so long as the samples and the case property remained with him, they were not tampered with or they remained intact. On 9/9/2002 itself, the independent witnesses were available with the police. Therefore, the possibility that might have been drawn at the police station cannot be ruled out, especially when the seal were not handed over to the independent witnesses. Here in our case, my lord, the seals were never handed out to the independent witness. It remained in the hands of the complainant, from whom the very same day it was recovered, seized by the IO of this case. So IO had the seal, the property. So it can be very well presumed that it can be tampered with. That is the sole reason why the seals are being handed over to the independent witnesses immediately after completion of the seizure. And those seals are taken back once these samples are sent for CFSL examination. Till that time, it is not there. Now, my lord, with regard to the 313, my lord, I said that there are so many discrepancies. What has not been said has been put.
Yes.
Now, my lord, may kindly come to next page, my lord. Next page. Furthermore, these material facts, that is link evidence, have, my lord, second paragraph, my lord. Furthermore, these materials, that is link evidence, have not been put to the accused in the statements recorded by the court under section 313. Nothing has been stated regarding retention of samples, their transmission, and they being intact. Recording of the statement 313 is not an ideal formality. The accused must be disclosed as to what are the incriminating articles against him. This was not done, my lord. ये दीजिए. This is again with regard to the non-compliance of section 55. That is, the officer in charge should receive, and the report has to be forwarded with regard to section 57. My lord, may kindly come to paragraph 21, my lord. Reference. Kailash Sahani versus State of Bihar. Law and paragraph 21 may kindly be. I'll give you the copy. Here, under these facts and circumstances of the case, the articles which were seized on 18/6/2006 and were kept in the police station, but there is no mention where the articles were kept. There is also no mention that the said articles were kept in the Malkhana, as the Malkhana register has not been produced, and hence there is non-compliance of section 55 of the NDPX Act, and there is no evidence whether the seized articles were kept where the seized articles were kept from 18/6 to 11/6 when the articles were produced, and this raised the doubt whether the articles seized were actually produced before the magistrate, from which the samples was taken out. And further, as per the evidence of the investigating officer, only from 2 packets the samples was taken, and hence there is non-compliance of section 55 and 57 of that. Hence, I give the appellant benefit of doubt.
Any other further judgment?
My lord, this is the most important judgment, my lord, because earlier some of the court said that merely if somebody is asked an option as to whether if he wishes to be searched before the nearest magistrate or nearest gazetted officer, that is not compliance. The accused has to be apprised. In a legal terminology, it has to be stated.
Yes.
Just merely asking that if you wish, because there was 2-3 Supreme Courts had a divergent view. Subsequently, it was decided by 5-bench judge.
Yes.
And then they have said that it is not a mere formality. It has to be strictly complied with.
Regarding section 50.
Yes.
Refer me the paragraph.
No, Baldev Singh. Baldev Singh, they have relied on Baldev Singh and then they have passed this. My lord, para 21, my lord.
Yes.
We would now deal with the 2 decisions referred in the referral order, whether substantial compliance with the requirement embodied in section 50 of the NDPS has been held sufficient or not. The Prabhakar Shankar Dubey 2-bench of this court called out the ratio of Baldev Singh on the issue before us as follows, where the officer concerned, my lord, this full, my lord.
Yes.
And my lord, this is the last judgment. Not obligation to keep the samples in a intact manner till the
Yes.
same is sent to the CFSL. My lord, it has been reflected at para 25, 32 and 33, my lord. 25, 32 and 33. And my lord, how the learned court below has dealt, my lord, may kindly see. I'll just read one particular from the judgment. I'll read out, my lord.
Yes.
From the judge.
Observation.
Yes, my lord. My lord may kindly come to page number 16, my lord. Page number 16 of the judgment, internal page 62, my lord. Page number 62. My lord, it was rather
Yes.
I'm just reading last 3 lines of the first paragraph, my lord. Section 42 of NDPS Act provides that information relating to personal search was served to the accused in presence of the independent officer. My lord, this is the finding, my lord. It has been copied and pasted rather, my lord. What has been done? I'm not so very sure, my lord. Then again, very next paragraph, it is copied and pasted, my lord. Section 42 of the NDPS Act provides the power to earth century. That means copied from one paragraph, pasted here, then copied, then pasted, my lord. Forty-two is not related to personal search, my lord. Now, presumption will only arise if the provisions are strictly complied with. If the mandatory provisions are not complied with, then the presumption that is there, yes, it will not be attracted, my lord. The manner in which 313 was done, the manner in which the judgment was delivered. These are the judgments, my lord.
Okay, very hard. Okay. On Monday.
My lord, that thing, my lord has taken note of it, that difference in that GD number, my lord, in the seizure memo and in the FIR, it
Yes,
shows
yes.
001.
Yes.
And in the other it shows 34, my lord.
Yes.
And that, my lord, written complaint, my lord, wherein they have in the written complaint.
GD entry number in seizure is different.
Yes, my lord, one last thing, my lord, may kindly see. My lord, if my lord just go through the FIR, my lord. Page number 21, it starts, my lord. This is the FIR. And kindly come to the last portion, my lord, at page number 23. What I have pointed out on the earlier day. Arrest was, and thereafter a case was registered after reaching the police station. My lord, it is there in the FIR. It should not have been. It is there in that Hindi note also, my lord. It is there in the Hindi note also, my lord. I have shown it.
Yes.
And how I am saying, even the number is mentioned, my lord. Because the FIR was chalked out on the basis of exhibit 4 may kindly be seen, my lord. Once last.
I understand.
Lastly, they have even
The
written the
number of
FIR
the
number.
FIR also
Yes, my lord.
In the Hindi noting,
Yes, my lord.
Hindi information. Act.
Yes.
Okay, please take down. The argument on behalf of the appellant concludes. This is the matter 16th for hearing on behalf of the state.
Obligement.